take over the party, throw him out, and come to the house.
There before disqualification.
No, all that time is not there. By the time they go to the party, to the election commission.
Because that is why, that is precisely my argument.
Therefore, Mr. Sibal, your argument, I mean, stretched to its logical conclusion would mean this, that even if a chief minister of a party completely loses the confidence of his own party in the house,
Yes.
whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which means that, according to you, therefore, that a chief minister and a willing ally in a speaker,
The speaker will have to be with him. At least two people will have to be.
people have to be. There are two of them, you can support, because we are not dealing with a defection.
No, I understand.
Where you lose your own party,
But
but then you continue because you have lost your own party.
I'll tell your lordships, then what will happen? It's very simple, Manas, then what will happen? Then what will happen is that under the scheduled Manas, the speaker will be removed. Without anything, without any other thing, Manas. The speaker a motion will be passed or whatever, the speaker may be removed and another speaker may be installed. But that's another issue.
That's the
That
notice
situation has not arisen.
Exactly the notice.
At the moment, we are Manas on what? From what date does the disqualification of the speaker
It's an
commence?
important question, Uddhav.
That's all. Now, Manas, let me now read something, Manas, the Constitution itself.
Yes.
For a minute. No,
I think you've now made your submissions on the reference or the lack of reference.
I'm sorry.
The same thing, whether the reference needs.
Right, now just one other. Just one other thing. There's a judgment of the UP Allahabad High Court, 1964 judgment which deals with this issue, luckily.
64.
And I tell your lordship what the judgment says. Then I give your lordship judgment.
Yeah.
But there the question arose that a chairman of the Legislative Council was sought to be removed. Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion. Right? Leave was refused. So, Manas, the question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought. Because the resolution only comes up for consideration when a particular day is fixed for its consideration. Precisely what we've been arguing before your lordship. That's the judgment. Let's give it to my lordship.
Yes.
Yes.
Now just see, but just the facts. The petition under Article 226 has been filed by Dr. So-and-so, who is a member of the Assembly. The three opposite parties in the petitions are so-and-so. On 11th February, Faridi and 8 other members of the council gave notice of resolution. Following resolution, Raghunath Vinayak, Dhulekar, being unfit for the office of the chairman of the council, should be removed from the office under 143 of the rules of procedure and conduct of business of the council. Under this rule, a resolution for the removal of the chairman can be moved only if the leave of the house is given for the purpose of 20 members, by 20 members of the house, rising in support of the same, when so required by the chairman to do. The question relating to leave was included as item number 3 in the agenda. On 2nd March, Raghunath Vinayak, Dhulekar, the chairman of the council, was occupying the chair. After the first 2 items of the agenda were gone through, he put the question relating to leave for the aforesaid resolution to the House and asked such of the members as were in favor of leave being granted rising to their seats. And on only 18 members rising, he announced that the leave had been refused. Dr. Faridi and others protested against Dhulekar himself occupying the chair when this matter was put to the House and later walked out. But we are not concerned in this petition with what happened after the chairman had announced the decision of the House. Dr. Faridi has prayed in his petition for a writ directing or order in the nature of mandamus against the opposite parties to the effect that the proceedings relating to item 3 in the agenda of 2nd of March be treated as ultra-virus, the Constitution, and not effected, and further ordering the chairman to proceed according to the provisions of Article 183, 185 of the Constitution. 183 is para-material to 179. Without applying Rule 143 aforesaid, on the ground that it was ultra-virus and illegal. So then this matter is discussed. Para 47.
Page 72.
Page 72. My lords have for
Yes.
The words used in clause 1 of 185 are while any resolution for the removal of the chairman from his house, his office is under consideration. And the plain meaning of these words, of course, is that the chairman is required to vacate the chair only when the resolution for his removal from his office is itself under consideration. As has been pointed out earlier, Rule 143 of the Rules of Procedure and Conduct of Business requires that before such a resolution may come up for consideration before the House, leave of the House must be obtained, and it is to be granted by at least 20 members rising in their places in its favor. The rule is within the rule-making authority of the Legislative Assembly under 208 of the Constitution, and the Council having itself provided under this rule that leave of the House must be obtained as a condition precedent to the resolution being moved or for consideration, it cannot be said that the resolution itself was before the House when only leave for moving the resolution was being asked for. Next is, some arguments were advanced as to the meaning of the word consideration used in clause 1 of 125 according to Webster's such act of considering, careful thought, attention, etc. Then the dictionary, rather than just leave a few lines. It is, however, not the meaning of the word consideration which is important. When there is some matter before the House, there is bound to be something before it for consideration. If the resolution itself had been moved, that resolution would be before the House for consideration. And if the question regarding the leave of the House for the resolution being moved was put before the House, it was that question which was under consideration. What is important for being noticed in this connection, therefore, is that not whether the House was considering any matter or applying its mind on the consideration of any matter, but the particular matter which could be regarded as being under consideration of the House. As has just been pointed out by us earlier, what was under consideration of the House was not the resolution itself, but the question as to whether the resolution was to be allowed to be moved. So long as the resolution had not the necessary leave, it could not be before the House. Well, that's, I'm just pointing out that there's a judgment there. Well, there's two last things that I've done. One is, well, let's kindly read now 179 with me. Last thing. Some words, Mullahs, have been glossed over, which I'd like to invite my Lord's attention to. 181.1. It says, it starts with the expression, at any sitting of the Legislative Assembly. It's very important, those words. While any resolution for removal of the Speaker from his office is under consideration. So, Mullahs, it has to be a sitting in the Legislative Assembly, not outside, while the resolution is under consideration. So it gives you the time, the point in time.
Your point.
Yes.
Yes.
Not at the time when leave is granted, not any time earlier. While it is under consideration, the Speaker, or while any resolution for the removal of Deputy Speaker for his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of clause 2 of Article 180 shall apply in relation to every such. That's the only embargo. So, Mullahs, the Constitution gives you the point in time, Mullahs, that he cannot preside. Now, this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So the whole premise of the argument is untenable.
There are 2 points here.
Yes.
That is, while is one aspect, and other is that this talks only about himself. And
That's all my contention is. You can't make a constitutional assumption, Mullahs, because the whole argument has been on the premise that there's a constitutional assumption that he'll act mana fide. When Kyoto Holohan, just that paragraph of Kyoto, Mullahs, I'll give to your lordships, says you can't attribute to the Speaker any such mala fide. That's why the provision of the 10th schedule was upheld. And just give your lordship just the page. I marked it on the. Just that paragraph I'll give to your lord.
You so easily vacillate from reposing such great confidence on the Speaker on the one hand. Within a split second, you would again, I'm saying.
I agree.
In a split second, we know how the speakers have worked.
That's true. But that's precise. That is why.
These two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives Speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the speaker. Yes. Now, the paragraph is,
Sorry, I could not hear.
it was Judgment Compilation 1, page
He would have made
135,
I
period.
said auto judge, right?
a noble judge, a noble chief justice making a noble assumption about.
Yes.
Yes. The whole
That's not how
paragraph
things,
about-
that's not how things have panned out.
Those are
after
different
92.
times. Those were
But Malad, the point is you, as a constitutional court, cannot on the assumption proceed that he will act mala fide. That's the point. That's why your lordship keep on asking me, what if he does this and what if he does that? That constitutional assumption you can't make. Otherwise, he should not be the authority which adjudicates.
But can we overlook the situations that have been thrown up after 92?
No, I'm not saying overlook it, Malad. I'm the last one to say overlook it, Malad. In fact, I'm the one to say he should not have that authority. But I'm saying as the law stands, so just note them, I will not read it. 115, 118 and 119. And 119, it says, accordingly, the contention that vesting of adjudicated functions in the speaker would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected.
Yes.
Anyway, I'm deeply obliged to your
Thank you,
lordship.
thank you.
I see the Chowdar as the many lordships. In the event your lordship is not sitting in a constitutional bench in the afternoon, then I can finish in 10-15 minutes.
What do you want to do?
Because this
Then you can conclude.
I thought so, because
Yes. Nice.
Your lordship will pardon me.
Yes, yes, sir.
Yes, deeply obliged. And I'm grateful to your lordships for the time you've given.
Thank you, Mr. Siddharth.